I did attend that wellness CLE. It was great.
Oh,
Um,
good.
it was one of the first times I've ever attended something like that on Zoom, and I didn't think that it took away from the impact of the materials. It was very engaging the way it was set up from beginning to end. I found it was very helpful. So I was one of the thousand.
Oh, that's great to hear. And I definitely will pass that on to Lita Abella,
Okay,
who
yeah, great.
presented that day.
Yeah, great.
Any other questions? Okay. Next on the agenda is item 3A, approval of March 15th, 2024 open session minutes. Are there any modifications or corrections to the open session minutes? Seeing none, may I have a motion and a second?
This is Heiting. I'll move to approve.
I'll second. LeSage will second.
Michelle, could you please call roll?
Yes. James Heiting,
Yes.
Lisa Johnson,
Yes.
Tracy LeSage,
Yes.
Deirdre Nguyen,
Yes.
Elise Yenny,
Yes.
Heather Benton.
Yes.
Okay, that's unanimous pass.
Great. All right, so we'll now turn to the business portion of the agenda. Next on the agenda is item 4A, the Other Bar Annual Report. A copy of the Other Bar's 2023 Annual Report is attached to the agenda. This item will be presented by the Other Bar's Board President, James Heiting.
Good afternoon, everybody. I've been tasked with this report to give you. I just want to start out with a little introduction of the Other Bar. You know, the Other Bar is a organization of lawyers and judges that help other lawyers and judges and legal staff with issues of chemical dependency or mental issues. It comes about through the Business Professions Code 6231C, which states one member of the board of directors of a statewide nonprofit organization established for the purpose of assisting lawyers with alcohol or substance abuse problems, which has been in continuous operation for a minimum of 5 years, will be part of the board, which thankfully and gratefully is fallen on me. We get as the Other Bar, $1 for each $10 of active bar dues that are paid by active members, I should say. The other $9 goes to the LAP. The Other Bar, in response to Business Professions Code section 6140.9, has some accounting responsibilities, and they include an accounting of all receipts and expenditures of the funds, the balance of the funds as of the end of the previous calendar year, a brief narrative describing the goals and work supported by the expenditures, and a summary of the number of clients served, the modality of treatment, and any outcome data on the impact of the treatment. So Ernie Bank, then president, had a report prepared that was submitted on March 1st, 2024, reporting on the 2023 year. And that report generally is provided available to you along with my letter that explains some further information on the report after an inquiry by Melanie Lawrence, who asked us for some further information. So those things are available to you, but I'll just run through it if in case you haven't seen it or in case you want to know what's in there. All right, so this report is made pursuant to Business Professions Code section 6140.9B. The total funds received by the Other Bar for the year 2023 were $194,743.25. And the total expenditures were $192,387.42, which went primarily to payment of 2 full-time consultants we have that work 24/7 the website that we put together and updates on the website, publications, hotline, subscriptions, bookkeeping and fees, and insurance. And those really don't cover nearly all the expenditures of the other bar. The other bar lives on voluntary contributions and some other charity that we get from other people as well. So, so the difference was about $2,000 that was an overage over what the other bar spent. The other bar provides free, confidential, anonymous, and voluntary peer support, generally speaking, for alcohol dependency, substance and chemical dependency, substance use and abuse, and mental and health disorders such as depression and bipolar issues involving drugs and alcohol. We are facing now the challenges of anxiety, depression, addiction. Increased attention is being given to wellness and outreach, and it's really good and positive to hear Catherine's report on what's happening with wellness. And Greg Dorst is available, and he will be able to answer any questions you have regarding the wellness program. He's considered a very high expert in wellness evolution, we'll say, in the American Bar Association, as well as nationally in the different legal organizations. So in case you have any questions, he's our Southern California consultant as well in the other bar, and he'd be happy to answer them. Stressors, of course, are very high in the legal profession, and we provide a free, voluntary, confidential method of assistance to California lawyers, judges, and law students, families, and staff. We have a hotline that we answer 24/7, and then we use that to direct people to different modes of therapy, whether it's hospitalization or inpatient or outpatient or counseling or whatever the mode of therapy kind of suits their lives, whether it can be religious even, or anything else that we feel would move them in the right direction. The consultants are tasked in part with developing resources that are available throughout the nation, and especially in California, that are available to these people to fit their finances and their needs psychologically and physically, so that they will get the best advantage to their recovery attempts. So we have Zoom technology that we instituted, of course, because of COVID. And we have 23 meetings online every week. We also have 9 in-person meetings. So we have a total of 32. The report says 31, but it's actually 32 meetings per week. It's very helpful in a way to have these video Zoom meetings because people can stay anonymous. You can see like Lisa's got her video off. We can have the video off as well as, I didn't mean to, you should put it on now. So, I mean, we can have the video off, we can have no names, we can have complete confidentiality, complete anonymity. And people appreciate that, especially when they're new to the program and they're new to trying to get help. It's a little avoidance of the shame factor and the ability to be welcoming that makes a big difference in our kind of line of work. We do a lot of MCLEs, probably 120 a year. That kind of supplements the LAP's outreach as well. We try to dovetail all of our MCLEs with the LAP. We try to promote the LAP as well as the other bar. We know that LAP provides a very good avenue of recovery. I want to tell you that it's one of the primary things that I wanted to announce was the other bar's pleasure and gratitude for the good working relationship that has developed with the LAP. It really has been a pleasure to see how things have grown and developed in a very positive direction. when the LAP and the other bar get together and move in the same direction, which has been happening lately. There are trainings, the seminars. We have an outreach to law schools. We have several law schools involved. They're listed in the report. There's a lot of them. We have a weekly remote meeting available to law students that not many take advantage of right now, maybe 10 a week, but we're hoping that grows. The thing that we've had a problem with live meetings at law schools is that they have a turnover of students, right? Which is kind of natural. And so the leaders of those meetings turn over because they go, they become lawyers and they go somewhere else. One of the greatest things about the other bar is that a lot of times you won't see any of the reports of these particular lawyers in the discipline pages because they never get there. They get the help that they need. They get a little oriented to wellness and health, and they never make it to the discipline pages. So that's really a good thing. The other thing is that how many people are helped by the other bar? It's very difficult. And I'm planning to meet with Melanie, see if we can work out some other things. She wanted some numbers that would support some of the activities that we engaged in. And while we gave her generalities and some ideals as to what we believe are happening in the recovery community through the other bar, perhaps we can develop some other numbers and we can do some things that will suit your reporting requests a little better. So we'll be happy to do that and talk with you and work with you on that. So the report goes further, talks about partnering with the California Lawyers Association in the wellness outreach, student outreach, firm outreach. We go to a lot of firms. We presented to firms that have as many as 1,500 lawyers at a time, on the video and remote. And we really do a lot of outreach and good work in that direction. We go to seminars. We go to the not the California Trial Lawyers, but the Los Angeles Trial Lawyers Association seminar in Las Vegas, which has like 4,000 attorneys in attendance. We also go to the State Bar Convention. We provide a host room so that people can come and relax and go to meetings there or just quiet down a little bit. They can go there off hours as well as at the time of meetings. We have meetings there and that sort of thing. We tend to find that the MCLEs really do promote telephone calls. We usually can experience at least 1, 2, or more calls after an MCLE presentation when people are inquiring about themselves or their loved ones or their friends or their bosses or their judges, to see how we can help out. I think I've droned on long enough. It's quite a good organization, does a lot of volunteer work. A lot of the work is done through volunteers. So we have these 2 consultants, and you can see that they get paid for their work, but it's modest in comparison to the results that we get. And that's because we have 32 meetings of people, of volunteers. We have maybe somewhere from 10 to 30 people, or maybe 6. I've exaggerated on that, maybe 6 to 30, or sometimes as low as 4 people in a meeting to 30 people in a meeting. But then you have the fingers that go out from there to the people who take advantage of those meetings and rely on those meetings in case they want to attend. So it's much more expansive than what it sounds. But those people are all dedicated to helping other people get into recovery and get some help. So that's the report. I'd be happy to answer any questions. Mr. Dorst, if you're on, if you could, is he available to talk? Can he talk?
I can turn on his, allow him to talk. I just clicked it.
Okay. Greg Dorst, this is the Committee for Lawyer Assistance Programs, along with the staff of the State Bar, who support us so well. And I'd like you to go ahead and speak if you wish. Keep it somewhat brief. I've been going on too long and we have business to do. So Greg Dorst.
Sure. Really good to see you, Michelle. Great to see you, Tracy and Heather and Catherine. I know many of you in this group. The other bar is well known to people, I think, in wellness circles. I certainly hope that that's the case. We've been working to make that happen for many years now. The other bar has been around since 1973. I've been a consultant for the other bar since 2004. So I have a great deal of experience working with lawyers who are suffering from substance use disorders and mental health issues. I'm an addiction specialist as well as a JD. I practiced law for nearly 3 decades. And I have an extensive background in working with lawyers as well as other professionals. We have a really amazing network that is, I think, well known to the LAP program in many of the case manager circles. We are referred and we refer a lot of lawyers who come to see us. And, I think probably it wouldn't surprise me if every lawyer that comes into in active practice who comes into the lawyer's assistance program is not requested through their treatment plan to attend meetings of the other bar, or at least given the opportunity to do so. We've been around a long time, and I can answer a lot of questions that you might have if you need any background, or if you have specific questions about what goes on a day-to-day basis. So,
thank you, Greg.
You bet.
Any questions or comments? Anybody?
No, thank you for all that great work.
Thank you. Thank you. I again want to express the idea that the other bar is very grateful for the relationship with the LAP and grateful to be able to take the opportunity that is provided through the statute and through the contributions to do the services that we do. So thank you. That's my report. Thank you very much.
Thank you, Jim. Okay. Next on the agenda is item 4B, working group recommendation for LAP rule changes. And just so you'll see, there are 2 attachments on the agenda on this topic. There's the proposed red line version, and then the second, and that is showing the current state bar rules that govern the Lawyer's Assistance Program with the markup of recommended changes. And then new added language is in blue and stricken language is in red. The second document is what the rules would look like with all the above changes accepted. And that document is entitled Proposed Changes Accepted, Title 3, Division 2, Chapter 5, Lawyer Assistance Program, Rule 3.240. The working group on LAP rule changes is myself, Heather Benton, Jim Heiting, and Justin Delacruz. Also present for this agenda item is State Bar Staff Attorney Armin Komili from the Office of General Counsel. Mr. Komili was invited to this meeting in the event that anyone has any questions on this topic that he can better answer.
Okay, Jim Heiting again. Justin isn't available today, so we did go through these, and we were talking about, are we talking about the Title 3, the 3 Series Rule 3.24? Okay, all right. So we went through those and discussed suggested changes, and then I was able to meet with Melanie Lawrence over the phone yesterday and discuss those changes. And I think if you all refer to her latest correspondence with...
I'm so sorry to interrupt you, Jim. I can put that on the screen if you'd like.
Okay. Yeah, thank you.
So hopefully you can all see that now.
Coming. There it is. Okay, so this, I think the easiest way to look at this is take her latest iteration here and with her comments and go through it. So it's our suggestion from this subcommittee that these changes be adopted as I'm going to go through them in a minute. So if you look at rule 3.240, it indicates with the change and with the suggested change that Melanie has included in the comment section, the board has created the Lawyer Assistance Program, LAP, to, in part, satisfy the requirements of Business and Professions Code 6230 et seq. And the other changes as indicated in the original document that was sent out, and that would summarize page 1. And so we would recommend that the words in part be added there where it says to satisfy in part the requirements, and that the other changes as indicated be adopted. If we go on to page 2, yeah, I would put a comma before in part and after in part, but that's my comma, fetish. I don't know. All right, so page 2 had no changes beyond the original document that you've received with the proposed changes, and we would recommend that that be adopted as is. We go to the next page, which would be page 3 of 9. There were some comments as to 3.244, eligibility, is stricken, and monitored lap is the description. So if I understand this right, and I think I do, the A section would read with the changes, the monitored lap describes the following program and is open to eligible participants who have volunteered or been ordered or required to participate and who have a diagnosis recognized in the most recent update to the Diagnostic and Statistical Manual of Mental Disorders that affects competency and is treatable by treatment protocols, etc. So those are the suggestions that are indicated. However, Melanie and I discussed this 2 areas that are in question, and that are when we talk about the statistical manual of mental disorders that affects competency, the statute does say that it does speak about the program affecting competency, or that the program treats or is to help with the treatment of chemical dependency or mental disorders that affect competency. But I'm not sure that the word may affect competency or can affect competency shouldn't be better, rather than having a standard that the people that get in have a disorder that has affected or affects their competency at this point in time, rather than may affect their competency. And the other thing is that when we go on to the rest of that sentence, affects competency and is treatable, I would prefer to see may be treatable or is considered treatable. But so the way I would suggest it was that most recent update to the Diagnostic and Statistical Manual of Mental Disorders that may affect competency and is considered treatable by treatment protocols that the clinical review team determines can be monitored. However, those are my suggestions, but I will say that I'm okay with the suggestions of Melanie that leaves the word affects without change and leaves the word is without change, although that is a stronger feeling that I have that should be is considered treatable rather than it is treatable. So it's just little word changes that I suggest. But anyway, so I think this would be a topic for discussion. So in case you want to talk about this right now, I think I will suggest that the committee adopt the section, the rule 3.244, as indicated by Melanie, with the change of is considered. So it would read this way. The monitored LAP describes the following program and is open to eligible participants who have volunteered or been ordered or required to participate and who have a diagnosis recognized in the most recent update of the Diagnostic and Statistical Manual of Mental Disorders that affects competency and is considered treatable by treatment protocols that the clinical review team determines can be monitored by LAP. That's going to be my suggestion.
I'll wait before typing that in so we discuss.
Okay.
Yeah, I was going to say, is there any discussion regarding Rule 3.244?
I think I agree with Melanie's comment about the potential concern about adding may before effect, just because that kind of opens up for a hypothetical concern rather than.
We're willing to, our committee, subcommittee is willing to drop that word may. So
this one here?
Yeah.
Okay.
Otherwise, I do like the addition of considered treatable.
One of the things, oh, it looks like Lisa was going to say something. I'm sorry, Lisa, go ahead.
No.
Okay.
No, please continue.
Yeah, I think you're on two sources. Can you mute one of them, please? Because we're getting some feedback.
Sure.
Okay. So one of the things I want to say, and this is something that we'll probably discuss a little bit later, is this idea of whether the mental disorder has to be linked to the issue that brought the person into the LAP program or had them under investigation or whatever. So my only question is, when we're saying that affects competency, are we saying that we're limiting it to people whose I guess whose competency is affected by this mental disorder and has a link to their negative behavior? Or are we saying that it, as long as it could, like, I guess, as long as it has the potential to affect competency, we're willing to consider them for the monitored lab program? So I guess as an example, an employer refers someone to monitored lab. They haven't really done anything wrong yet, but they're like, I want this person monitored. That would kind of fall outside of the scope of this, it seems, because at this point it hasn't affected their competency, but could in the future. So I'm just trying to get some clarity on that.
That's exactly what the word may was inserted for, because of that idea of what if it doesn't affect it right now, or it hasn't affected it yet, but it certainly will affect it.
I just have concern that becomes a pretty slippery slope. So I think for voluntary, it would be okay if it's may affect later, because then that person is opting in to say, I can see this becoming an issue. But if we say it may affect competency, that could be really any range of issues that could kind of, I mean, I think it just casts the net so widely that I have concern about it.
Yeah, well, this one, when you just leave it as it is, it means that there can be some wiggle room for people keeping people out of this program because there's going to have to be proof that this has affected the competency in their situation. Not that it will affect it or may affect it or it probably will affect it, but it has affected it. That it's affecting their competency as we, as we consider them. So just a thought.
Yeah, I agree with Jim too. It I think it's important. I understand what you're saying, Dr. Yini, because I see your point, but I also think the monitored lab has a voluntary component for someone being monitored. It has a component where like an employer or somebody else can refer them for being monitored, but it also has a function of the ADP people who've been ordered by the state bar court to come. So there's a piece of it that I think it's really important to say, like, hey, this may affect competency because there may not be a direct link to their offense for people who potentially have an offense or people who are asked to be monitored, but they've still got to have the diagnosis under the DSM, which I think would limit it from becoming such a slippery slope because they still have to have the diagnosis. So if someone is like, has something that's not really in there, that then they wouldn't qualify. It's like there's not a whole lot of issues. That's just my thought.
I think from like a clinical perspective, it's really hard to link just a broad diagnostic label to specific impairment, even if it is like directly causing that link. I know like I practice forensically and we don't use specific diagnostic labels to come to conclusions in like other arenas. And so I think if we use the may, then I think we need to link it directly to the voluntary component and not the mandated component. That's really where my concern comes in.
How about this as a compromise? If we look at the language, if we change that affects competency to affecting competency, in other words, these disorders do affect competency, it would be absolutely consistent with the statute. Let me read the statute to you. It is the intent of the legislature that the State Bar of California seeks ways and means to identify and rehabilitate attorneys with impairment due to substance use or a mental health disorder affecting competency, so that attorneys so afflicted may be treated and return to the practice of law in a manner that will not endanger the public health and safety. So we just strike that affects and put in affecting.
Yeah, I feel a lot better about that.
How would you feel about that, Heather?
I have thoughts, but I think Dr. Johnson had something she wanted to say, so I'll let her speak before I say anything.
No, can you hear me?
Yes.
I've been having some technical problems today. I didn't intend to raise my hand. I've been trying to fix my camera. I apologize.
No worries. So I think if we use that, then that's just simply to be consistent with the statutory language, which is fine with me. I just think that practically speaking, I think we have to decide like whether the monitored lab is really limited to people whose DSM diagnosis affects their competency, or whether it's whether we open it up to people who have a DSM diagnosis but maybe embezzled funds and it's not directly linked, but they could benefit from the program. And we kind of talked about this with Melanie and Michelle the other day, because it's one of those things that I agree with Dr. Yini. It could be a slippery slope, but I also am concerned that if you link it too much, then that does create a burden on the OCTC to prove that it's affecting competency or a burden on the employer to prove that it's affecting competency. So in some ways, I actually think potentially if we want to separate it into like the people who can voluntarily input may, that's great. I'm just concerned about, the language, but I understand it's consistent with the statute, and maybe that's where we have to go just to sort of resolve this.
All right, so ultimately I'll make the suggestion then that we change the wording after mental disorders from that affects to the word affecting. Yeah, right there. Get rid of the word that, yeah. Right. Okay.
Jim, are you wanting to, I think we should wait to vote on this in its entirety, but we can discuss each section as it comes up.
Yeah, however you want to do it.
Okay.
Okay. Okay, so the next one, if you move down the page a little bit to 3.244C, it says the committee will establish minimum requirements, and we want to insert the word reasonable, establish reasonable minimum requirements. Then if we move down, anybody who wants to talk about any of this stuff, please speak up. I won't feel bad if you interrupt, please.
I'm just wondering how you determine what reasonable means.
Well, you got to ask all those negligence lawyers about that,
Yeah, I mean, we're struggling with the definition of moral turpitude, so that's another legal term that can be interpreted in so many different ways. So
it's true. You're right. You're absolutely
curious.
Right. It's a little bit of I think it's a little bit of a caution light is all that we were talking about, a little bit of a caution light to make sure that whoever is establishing these minimum requirements has to think a little bit harder on, putting them in place. That was what the purpose of the word reasonable was. The next one is D, criteria for successful completion of LAP by a participant could include more than the minimum current requirements. And so I was inquiring as what that meant. Minimum current requirements identified where, and Melanie was kind enough to include the minimum requirements established pursuant to C above, which is 3.244C. That establishes the minimum requirements. So we're suggesting to include the words requirements established pursuant to Rule 3.244C.
Jim, I just want to quickly go back to see. I'm kind of with Tracy on the reasonable. It's kind of like that reasonable man requirement that we use in,
it is just like that.
It's like, what is reasonable? And I feel like,
okay, it was just
I think maybe if we said something like evidence-based, clinical minimum requirements or something, so it's clear that like it's based on something tangible, like when we talk about like evidence-based clinical therapy or whatever, as opposed to just saying reasonable. I guess that's my only thing is it feels sort of nebulous.
Okay. But I think that if you do evidence-based or you describe it any more particularly, you open it up for lots of arguments and maybe even claims of impropriety at some point in time.
Do we even need an adjective there?
Pardon?
Do we need an adjective there, or can we just leave it at
no? You don't have to have an adjective there. No, you can leave it. Does everybody want to leave it?
Well, Michelle was going to say something, so let's let her chime in, and then we can kind of figure that out.
I was just going to add in case it's helpful, because this is the subcommittee on successful completion spent a year on this last year talking about it, and it is very, very difficult to define. And the definition that the committee might end up deciding is reasonable might just be minimum requirement is 1 year, as an example. Like it might not be a specific, standard based on the person's diagnosis or lack of relapse or something. I just wanted to point out the complexities and remember that this is because in case it helps kind of set baseline for some of you, because you're working on working groups for the alternative discipline program, this will not relate to the alternative discipline program. It will not relate to somebody's what the court is saying they need to do for discipline. This is only the LAP rules. So the successful completion will be for any of the people who are being monitored voluntarily, like you said, their employer refers them, or other reasons that they're in the LAP. And we are not requiring anybody to complete. It doesn't change the fact that people enroll voluntarily. They can withdraw when they want to. It's only if they want to reach this designation of successful completion for their own satisfaction, or in case the court orders them to complete the LAP as a condition of their probation or something, they might be required by the court to do that. So I wanted to do a little of the information like base setting, but also this is, this conversation could last a year or more if we continue going into like how we're going to do the completion criteria right now.
Right. Well, Michelle, do you like that addition of reasonable? Does that help? Do you think it makes things easier?
I think, well, it's referring to the committee. So that's this group. I think it goes without saying that this group is going to be reasonable in coming up with what requirements you're going to ask people to do. I know that we're not asking people to do anything really outrageous. Like we never have. I don't see any precedent for it. What we're really trying to figure out is if people are have reached a level of stability that we know and changes in their life and lifestyle that will enable them to maintain that stability or sobriety going forward into the future. So that's really what we're trying to gauge. And so right now, the way we've had them demonstrate that is by writing an essay, talking about it, meeting with the clinical review team, participate, satisfying the terms of their plan, being in compliance. So I don't see this turning into something, unreasonable
I think I think you actually avoid arguments in the future if you leave the word reasonable out. Although we meant it as a caution sign to make sure everybody stayed within the bounds of reason. I think that we might create arguments. Well, that's not reasonable. Well, we're required to do something that's reasonable, and that's not reasonable. And so you might want to leave it out. It's not that important to me.
It wasn't
that important to Justin. So,
I say we leave it out, Jim.
Yeah. Okay. Let's leave it out for my suggestion. Okay. We'll just, for my suggestion, leave out the word reasonable. All right. So then we've talked about D. If we go to E, then a participant may be terminated from LAP if the clinical review team determines that the participant has failed to satisfy, is what it says now. And my suggestion is to change the word satisfy to the words comply with. Has failed to comply with the participation agreement rather than satisfy it.
No objections to that. I'll go ahead and.
All right, so if we go to page 5 of 9, then we're talking about the support services LAP under rule 3.245, I think. And that will be consistent with the definition of the monitored LAP when we include the language. So my suggestion is that it says the support services LAP describes the following program and is open to all eligible participants who request to participate, period. So that would be the first change. The second change is under B. It says the support services LAP shall provide confidential support, resources, and outreach to enable eligible participants to address behavioral health issues and substance use that may affect competency, and or, the word or would be added with a slash, and or to promote awareness of LAP. And then there's a suggestion, we were wondering in discussing this about why we wanted to just promote awareness of LAP. And I had suggested that we promote awareness of avenues of support and or recovery as indicated on this thing. So I was going to suggest that we change that. Instead of awareness of LAP, we would change it to awareness of avenues of support and or recovery. And Melanie, as suggested through her consideration with other people, I guess, she's spoken to that we would change it to awareness of LAP and organizations that provide services and support to attorneys with issues related to behavioral health or substance abuse. So while I'm just fine with that language as well, which would be awareness of LAP and organizations that provide services and support to attorneys with issues related to behavioral health and or substance use, I think that the simpler wording covers that if you just say awareness of avenues of support and or recovery. So I'm going to suggest, sorry, Melanie, that it says avenues of support and or recovery in that simple language, but I'm going to invite you to please tell us, because we haven't had a chance to talk since we talked yesterday. So if you think that it should be the more expansive explanation.
I just have a question about the location of the and or. Like, should it be behavioral health issues and or substance abuse?
Yeah. Yeah, I think it should.
It says competency and or to promote awareness.
I just think it might be helpful to put maybe another
and or both. Yes, you're right. You're absolutely right. I missed that. So and or substance abuse and or to promote.
Melanie?
Yes. So the suggestion.
Let's see. Behavioral health and so. Well, go ahead. You talk and I'll look at my notes.
Yeah, let's let Melanie.
So the suggestion really comes, and it's sort of laid out in the comment here, is one of the things that we are trying to do in revising these rules is be as true to the language of the statute as we can. And, the statute has been around for a while, and some of the language is, not in favor anymore. For example, we're using the term substance use instead of substance abuse, which you see in the statute. But we wanted to incorporate both the elements of promotion of LAP as well as trying to incorporate something that looks similar to the language that you suggested, Jim, by including awareness of LAP and organizations, etc. It is rather lengthy, but it is more true to the language of the statute.
Okay. And going back to Heather, the word and or, yes, should be between health issues and or substance use. It should not be after the word competency in that B section. So you were correct about that.
I think that was Dr. Yenny, but
oh, that was Dr. Yenny. Excuse me. So thank you.
I do have a thought as well, but I want to see if anyone else has any thoughts before I jump in. Okay, so I actually like the language that Melanie proposed because it is consistent with the statute, but I do have a question because up above, we took out the may affect competency, and here we have the may affect competency. So are we just distinguishing between monitored and support? Is this an oversight? I guess I need some clarity on that is the first thing. And the second thing is I in liking the language that Melanie suggested, I also wonder, there's a component of like education and wellness that we're doing as well. So I'm wondering, do we need to include that because this sort of limits, the language we have sort of limits it to behavioral health or substance abuse or substance use. And I'm just wondering. So those are my two questions.
We could actually just really cut it way back and talk about outreach. So you could talk about these things that are specified in Melanie's description and include the words "and outreach" available. I mean, when we look at the statute, the statute describes the outreach, and it describes all these things that we're talking about and all the things you were talking about. But
what if we just say and engage in outreach consistent with BMP section 6236?
Might make sense.
Yeah, it's clean.
Yeah.
Yeah.
I agree with that as well.
okay.
Okay, will you repeat what you said? You wanted it down here after.
Go ahead. Tell us where that should be, or how do you want to see that?
So substance use that may affect competency, and to engage in outreach consistent with Business and Professions Code 62, section 6236. And I think we need to have the section in there.
Yeah.
Section, yeah.
I don't know where I have that symbol on my thing. But...
I think, Armin, did you have something that you want to add?
Yeah, just from a drafting perspective, since you're noting a specific statute, I'd recommend putting at the end of that statute as may be amended in the future, something along those lines. In case the legislature does change it to a different section or something along those lines, you're still capturing it.
Would you consider, Heather, just the word promote outreach and then just include Melanie's language? So substance use that may affect competency and to promote outreach and awareness of LAP and organizations that provide, et cetera, instead of referring to a statute.
I just feel like it's really long. If we want to take out the specific section, that's fine. I just feel like it gets really long. And if we just keep it really simple and clean, it leaves less room for like debate and litigation later. You know, just keep it really simple. You know, I know Catherine's kind of going and, you know, doing several things with the support lab. And I don't want us to get locked into, well, this isn't, you know, it doesn't fall into the definition of what the rules put.
I think it also gives a little bit of legitimacy that we're not just making it up or like pulling it from somewhere else.
Yeah, and then including, I like the suggestion to make sure, because it could be amended.
I agree. Yeah, thanks, Armin.
So, I mean, what was the wording that you had after this, or will you add it before this goes to the board anyhow?
Well, I do want to make sure that the version that we have here is the version that this group is voting on. So I want everybody to know what they're voting on.
So let's go to health issues and or substance use that may affect competency and to promote. Heather, what?
And we're going to keep that, but Armin had an amendment to add. Armin, could you give us the language for that?
Sorry, I started talking without turning my mic on. So the BMP section 6236 and then comma as may be amended.
May be amended?
Yeah,
why would we include that?
In case the legislature changes what that actually is dealing with.
Yeah, so sometimes, Jim, the legislature changes section numbers or they move things around. And so I think what he's saying is like, it's consistent with 6236 as it's defined, but it could be amended. And so we want to make sure it's consistent with whatever it's amended to. So we don't have to rewrite the rules if the legislature changes the code sections. That's my guess. Is that what you're saying, Armin?
That's the intent, is to try and capture, like you said, let's say they do a reorg or they change what is actually in 6236 to be something else, that the rule will capture what it is.
Okay. I don't think it's very descriptive just with that language, outreach, but it covers it. I mean, it does cover it. So I'm okay with it. I'm okay with it.
Jim, what if we say as may be amended by the legislature? Would that help you or no?
Doesn't help me because I don't see any reason to put it in as may be amended in any statute because all the statutes can be amended. So I don't see the need for that. But
I mean, you could also do a broader citation to it if that's what you're concerned about, that dealing with like Article 15 of Chapter 4, Division 3 of the Business Professions Code, which is the entire Attorney Division and Assistance Act.
You're gonna make me read everything, huh? That's bad, man. That's no good at all.
I mean,
I actually like that, Armin. I think that covers the whole section. So in case they move it around, I think that makes sense, actually. It makes a lot of sense.
Okay, Melanie, I want to ask you, what do you think about all of this?
Well, I like sort of the broader strokes because it then we don't have to come back and amend the rule every time the statute changes.
All right, so you're okay with what was suggested by Heather then? I take it.
Yes. Yeah.
Okay, great. Let's do that.
I'm sorry. Well, I do want to address, Heather, your comment about the may affected. It's a good catch. I don't know why it's there, and neither does anyone else that had a role in this, I don't think. So to be consistent, we probably ought to say substance use affecting. I think that's what we did in the earlier version. Yeah.
Yeah, we did.
So you see that, Michelle?
Here.
So take out that may. Yeah, and take out that may.
Yeah.
Okay. It's all right. Maybe the word disorders can go in after substance use. Let's see.
You want me to have disorder after substance use?
What is the eligible, Jim, do you remember what the eligible participants says? Does it require, for all of the eligible participants, does it require DSM-4 or DSM-5 diagnosis, or is it only the monitored that requires that?
Only monitored.
So I would hesitate to put disorders here because I think that kind of conflates the two and assumes that there's a diagnosis as opposed to somebody who has a substance use issue.
Well, then I would suggest you drop back to the may affect because you're no longer in that strict adherence to the statute, and I mean realistically in this part of it, and the reason that affecting competency is adequate in the one before that is because we're talking about disorders affecting competency. We're not talking about a disorder that has affected their competency, but we are talking about disorders affecting competency, meaning this disorder affects competency. And so if we're not going to have disorders affecting competency, I think it would be better to use that may affect competency here. But
I think the main difference that I see is the voluntary versus mandated. I think in voluntary, it's okay to say may affect because that's kind of a preventative, like they're opting in. When it's mandated, then there's just a lot more kind of legal recourse that could be sought if they feel like the criteria for them being mandated is too hypothetical. That's what my concern is. But if they're volunteering, then I think it's more okay to say may affect.
Yeah, I didn't chime in earlier, but I agree with you, Dr. Yanni. I'm following your train of thought.
Okay.
So
I guess.
Okay. So, okay. Yes, go ahead.
Well, I was just going to say, I just want to make sure that to the extent we can be consistent with the statute, that we are. So
That's
I don't
true
know.
too.
Armin, do you?
Well, given that both programs are operating under the same statute, I think when you're expanding one program just because it's voluntary doesn't necessarily make it there could be an argument that it's not within the bounds of the statute simply because it's voluntary or not. So whether you're doing a voluntary version through Support Lab or you're doing the monitor version, they still should be both within the bounds and scope of the statute because that's kind of what's authorizing the programs to exist to begin with.
So do you think that us changing that, the distinction between the two might put us in a situation where we're now inconsistent
Well,
with the statute?
To bring it back to the statute, it mentions we're to identify and rehabilitate attorneys with impairment due to substance use or a mental health disorder affecting competency. So why don't we just use that language?
I think it actually, the version I'm looking at, and maybe I'm looking at the wrong one, says an impairment due to abuse of drugs or alcohol or due to mental illness affecting competency so that attorneys so afflicted may be treated and return to the practice of law in a manner that will not endanger public health and safety. So I guess this is part of a larger conversation and I want to kind of keep us moving through. So, you know, my recommendation is we keep it consistent. If we have to reevaluate what we're doing with Support Lab and what it looks like, we can do that. But I think I agree with Melanie and Armin that the statute is pretty clear about what our purpose is. And so we probably should stick as close to the statute as we can. But I will defer to the rest of the committee.
So you're suggesting that we strike out that may affect and change that to affecting, correct?
Yeah, because that's what our organizing statute says. Yeah.
I don't think I have a real problem with that. That's going to be serious. So I'm okay with it. How's everybody else feel?
Well, I know it makes it consistent with the statute. I think the concern I have is, I would prefer obviously to be consistent with the statute, but what if it may turn away people who are seeking help because they're not at the stage where their competency is at issue. So they would just have to do another program, I suppose, not this one.
And you wouldn't, Heather, want to insert the word disorder there?
I think that it goes to what Tracy was saying about turning people away when it's disorder. It's like, oh, well, I don't have a disorder. I just, drink 5 times a day, but that's not a disorder,
Right.
Like it's easy to rationalize. I'll be honest, this as part of the working group, this was kind of a section that we had a conversation about, if I recall, in terms of what Support Lab is doing and how broad are we reaching in this and that. And so I know that Catherine was going to kind of put together something for us in the next few months that we can chat about, I think in December. So I think that maybe we should have a broad stroke as much as possible to allow for kind of a malleable approach to this, so that, we can discuss it and have a conversation. And then worst comes to worst, we revise just this section. I would prefer not to, but I think if we keep it broad enough, we won't need to. That's just my thought. Melanie?
How about if we just change it, shall provide confidential support resources and outreach to enable eligible participants to address identified issues and to promote, and then the language. And so we just change it all to identified issues or relevant issues if you want. And to promote outreach in the other language you used there. So we get rid of all of that behavioral issues and substance abuse, or substance use. so old school on that one. So substance use that may affect competency. We get rid of all of that. And we just talk about relevant issues. They address relevant issues.
Armin, or Melanie, what are your thoughts about that? I want to check in with you.
I'm concerned that that's getting far too broad here.
All right, relevant issues in the area of behavioral health and or substance use.
This might be more of a question for the practitioners in the psychiatric and the psychology field, but is that the same thing as mental health, behavioral health? Is that a term of art at this point? Has that language evolved to a point where it's in practice we're talking about the same thing, or?
I mean, I would say so. Behavioral health is kind of more broad of what people are doing, whereas mental health is more like internal experience. But I think for the purpose of this, it's probably more splitting hairs.
So, Armin, do you think it's more important for us to be consistent with the statute in this case, since we're trying to do that, and say mental health, or if it's sort of one and the same?
Well, I think if the statute says mental health and you can define it some other way, you should say mental health.
So it does, the statute says mental health in that very first section.
Right.
Keep reading 6230. It does, though, reference behavioral health later on in 6236, where it talks about how we need to do outreach. So, like, for example, it says that outreach includes, but it's not limited to, the development and certification of minimum CLE courses relating to behavioral health issues. And then later on at the end, that we should be working in cooperation with organizations that provide services and support to attorneys with related behavioral health and substance abuse. So that's kind of why I was wondering if this is more of an evolution of the term in the field, or if there is an actual distinction.
Okay, so I think that's a good point. Go ahead.
I'm wondering this is to make it a broad stroke. If we just say support services lab shall provide confidential support resources and outreach consistent with whatever this business and professions code section is, what is it?
6230.
6230 et sec, and just kind of leave it at that and allow the support lab to work with the oversight committee to kind of craft something, as opposed to being really specific like this. I feel like this could create some issues. That's my recommendation at this point.
Revising it so it's referencing the article that created the Attorney and Diversion Assistance Act will allow you a lot more flexibility as those terms also evolve.
Agreed.
So that may be, if you're looking for a broader scope, but still within the statute, that's probably as broad as you can get while still being the statute, since you're citing the statute.
Yeah. I like that, Tracy. I like that a lot. So can you put that together, Armin?
Yeah. I mean, one of the ways you can, if you guys want to actually vote on this thing as written, I would recommend changing it, or whenever you're writing the reference, to reference it to Article 15. I don't know if anyone's taking notes on this one.
Well, right here,
no, we're going to take out the whole thing, Michelle, after outreach, and put in Article 15.
Well, you're suggesting you take out to enable eligible participants as well?
Yeah. So take out that whole thing and just say
consistent with.
Right here.
Right.
Yeah.
And outreach consistent. So all the
And it's Article 15. What's the rest of it, Armin?
So Article 15, Chapter 4, Division 3 of the Business and Professions Code.
Excellent.
And
62.
If you want to put in parentheses.
No, probably.
No, it's this is part of the citation for drafting purposes.
Oh.
So then you say commencing with section 62.
Right here of the
Yeah, right there where it says 60, you're gonna say commencing, right, with section 62, whatever.
So it's after you write the business and professions code. So
You want to, Armin, tell me, does that then, does that change in the future? I mean, is it better just leave it Article 15, Chapter 4, Division 3 of the BNP?
I mean,
Or do you,
it's the way it's traditionally drafted when you cite an article like that is that you do include the initial section.
okay.
But we can always also add that phrase as maybe amended in the future, something like that. But normally how I would do it, so consistent with Article 15 of Chapter 4 of Division 3 of the Business and Professions Code. And then
Chapter 4 of
Division 3
of the
of
Business
the
Profession Code,
commencing with section.
commencing with section 6230, 6230.
yeah, and
I
then
think it
the
should
whole
say BNP code, right, Armin?
it should be spelled out, Business and
Yeah.
Professions Code. And then the commencing part, commencing with section 6230, that should be in parentheses.
And I think code should be capitalized, as well as article, chapter, and division.
Yes.
Can we just take a look at it as a whole now here at Support Services and make sure that it makes sense now to have a subsection A and B, or if perhaps there should just be one subsection or one paragraph? Yeah. I'm not sure that we need these both as subsections.
I would recommend we keep A, and the reason being is that from what I recall from, and I'm looking at the wording on the act, I don't see where it specifically talks about the eligibility for support lab, but I could be wrong. I may have just missed it. So I'm just wondering if we need to include that so that people understand who's eligible, but I could be wrong. Maybe I missed it. It's very possible.
I'd like to leave it in. It's okay, I think.
Okay.
So if everybody's okay with this, any more comments on this particular section? Okay, then the last section that we've dealt with other than were changes before was the financial, the grant versus a loan and costs and fees. And those were all okay as far as Justin and I were concerned. And so as changed, as presented to you originally, they're fine. And so I guess I would move that the rules of rules.
Oh, I'm sorry. Can I make one quick change?
Yeah, sure.
Sorry. I was just for the commencing part in parentheses, that should actually be after the first thing that you cite. So I think it's Article 15. Because we're trying to say that Article 15 commences with that section.
Okay.
So what is the change? Article 15?
Article 15, and then that part where it's in commencing with section 6230 in parentheses, just move that to be right after Article 15. So it's Article 15, then the parentheticals, and then of Chapter 4, Division 3 of the Business Professions Code.
Yep. Yep.
Okay.
And I do think we have a resolution
We do.
on this. Okay.
Yeah. So the motion is, be it resolved that the LAP
I'm sorry, Heather. Before you read the resolution, I see that Lisa Johnson is not here, but she is as one of the attendees. Shall I try to promote her It seems like she's been listening, but
Yes.
not able to participate.
Yes.
Okay, I promoted to panelist, so hopefully that will work.
There she is. Lisa, we are getting ready to do the resolution on the rules. Did you have anything to add?
No, I do not.
So be it resolved that the LAP Oversight Committee hereby approves and adopts proposed amendments to Title III, Division 2, Chapter 5 of the Rules of the State Bar of California for recommendation to Board of Trustees, and further resolves that a request to circulate the proposed amendments for public comment be placed on the July 2024 Board of Trustees meeting agenda. Do we have a second?
I'll second Jim Heiting.
Great. Michelle, would you call roll?
I'm sorry, I had Jim as the one who proposed the motion.
Whatever you want to do.
That's fine. I was just reading it, so.
So who do we have who proposed and who seconded?
Jim proposed and I missed who seconded it.
I can second, Elise.
Okay, Dr. Yanni.
James Heiting?
Yes.
Lisa Johnson?
Yes.
Tracy LeSage?
Yes.
Deirdre Nguyen?
Yes.
Elise Yanni?
Yes.
Heather Benton?
Yes.
Okay, so that's unanimous. This motion passed. Resolution passed.
So, and I just want to let the committee know that what will happen is we will put this on the Board of Trustees agenda for July and ask them to send out the changes for public comment. It's usually for either a 45 or 60-day period. The way that the rule revisions are working is that we can only bring them back at certain times of the year. So November will be the next time that we can actually return the item and request hopefully approval. Although, you know, depending on what the comments are, there certainly could be additional changes to them. So thank you. And thank you, Armin, for joining us.
Of course.
Thank you.
Thank you, Melanie. Thank you, Armin. Thank you to the working group, including myself, James and Jim and
That's right.
Desmond,
Thank you. Thank you,
for
Heather.
all your help on this. Thank you. Okay, so I'm gonna try to keep us moving so we can get through this. It's about 1:34. So the next item on the agenda is item 4C, reports from the Alternative Discipline Program Project Working Groups. And we have the ADP process and procedures with Justin and Jim, ADP eligibility with Lisa, Phil, and Tracy, and then education on collaborative courts, which is Tracy and myself.
My report on the ADP process and procedure is very short. We've met, we've discussed it. We have preliminary outlines of ideas and changes, but those haven't been finalized, and we plan to meet after this meeting to go further with those things.
ADP eligibility?
Lisa, you want to give that, or you want? Because Phil's not here.
Tracy, you can, please.
Well, you want me to? Well, we've also met several times. We reviewed a lot of available data. We also reviewed, thanks to Melanie, she sent a lot of additional documentation, including some case law. We wanted to take a look at how moral turpitude had been defined over the years. And so she sent that information, we reviewed it. I believe the committee came to the conclusion, or our working group, that we either need to modify the definition of moral turpitude or take it out and replace it with something else. So we are currently still working on what would be the best route to take on that. We also considered whether there should be, you know, in reworking that, because I think we did see with reviewing the data that there has the participation has been impacted when the legislature changed to add that requirement. And so we also looked at whether maybe there should be some exclusionary crimes just to make it clearer, you know, which we discussed and talked about. You know, if you're automatically ineligible if you've done A, B, C, D. So we're working through that. But I think we'll continue to meet and propose either a modification to that or different separate language in general that makes it clearer. So that, I don't know if anybody else wants to add anything, but that's where we decided or came to.
So I would just say, and this is for all the working groups, the great thing about this project is you don't have to actually come to any decisions. All you have to do is make recommendations. And when we go back to the board in November, that's what the report will be, is recommendations. So there may even be in those recommendations various options. And then the board will decide how they want to proceed. It could be to, you know, assign out options to us or to other stakeholders for further consideration and work. It could be to, you know, further study the issue, for example. So don't feel like there's any pressure on you to come up with the right solution here. Just options.
That's great to hear.
Any questions on that topic, eligibility? All right, I believe Tracy's going to also talk about the education on collaborative courts.
Yes, so we met also multiple times. And then Heather and I actually met with Brian Richard with a T. Very, very, Melanie put us in contact with him. He was very helpful. He currently is the chief probation officer in El Dorado County. I think he said he'd been doing this for 27 years. He put together a proposal some years ago when, you know, the State Bar first began exploring the possibilities of a collaborative court model somehow in terms of whether it be included in ADP or something separate. So he actually put together a 3-page summary of how collaborative courts work, because we noticed with our original subgroups when we reached out to stakeholders, the main thing they wanted to know was more information about how a collaborative court actually works. So we thought it would be a good idea just to educate them on that. And Heather and I believe instead of putting together our own little one-pager, the one that Brian put together has a nice overview that can be, you know, obviously changed and adapted to fit if they decide to go with it. But essentially the main component would be just the addition of a consistent team, right? One judicial officer, a dedicated core clinician, probation would probably involve, you'd have prosecutors, defense counsel, whether they would be appointed or there would be a panel. Lots of things I won't get into. But Brian's model does, basically, it's based on the national model, which is NADCP, which is basically national standards for drug court programs, which now is called All Rise. So they have changed the name. It's called All Rise. And it's a multidisciplinary team. There's incentives, sanctions, testing, monitoring, and access to services, which is obviously key. He identified some challenges, which we took note of. One primarily being, you know, this is the state of California. So how do you make a one team, you know, when it's spread out throughout so many jurisdictions? But we also talked about the fact of technology and stuff like that to maybe make that work. But basically, after all these meetings and after reviewing data, it is possible that a collaborative court component would be possible, but we thought it best if we let the subcommittees that are working on the revisions come up explore that first, because it is possible that with those revisions, we'll see an increase in participation and success rates, and perhaps we won't need to explore a collaborative court model. But I think the recommendation would be to further explore it, work through some of these issues that Brian identified. Heather had done a lot of research. There are actually other bars that have programs similar to this. So Heather she might want to mention that, what she found out when she was did that research. But we would like to just keep exploring it, and if and when they decide they want to go in this route, we would be in a better position to make recommendations on if we do it, what should it look like. So I don't know, Heather, you wanted to add to that?
I think just a couple of things, and I'll be brief. Thank you so much, Tracy, because you gave a really comprehensive
You're welcome.
of a, somewhat complex topic. I did do some research, and what I found is that there are other states who have kind of different models of operating. Some of them have set committees that make a determination as to whether something's going to go towards a more collaborative route or administrative route, kind of judicial route. Most of those committees are set, so they're not just random people. I know Melanie was saying we tried that a while back and it just kind of fell apart because there was too much inconsistency. So that's one of the things. There's also Washington State has a respondents bar that they pay for when somebody has a mental health or substance abuse issue. They go through an initial trial phase of determining whether they have a disability and whether they need to go on inactive status or what needs to happen with them. And they are appointed counsel that is paid for out of the state. I don't know if it comes from the dues or taxes or what, but the state pays for it. The other thing we talked about was what I was getting at earlier in terms of the link between mental health and substance abuse and the action that occurred. And Brian was saying there didn't necessarily need to be a link, that, it's probably enough that the person has the issue that needs to be addressed, whether it links or not. So that's something that, we may, you guys may want to consider when you're looking at the ADP program, and whether it requires a link or it's more of, they have this issue and we need to address it. So those are the things that I thought about. We met with Melanie several times, like Tracy said, and she provided us a lot of information. I think the one thing we talked about too was rates of recidivism, and really trying to hone in on kind of what is maybe causing some of the recidivism to occur. We don't have the data now. One of the questions I asked is, is the recidivism going up after 3 years because people are now off of probation and off of being monitored? Or are we saying they've been off of being monitored and probation for the full 3 years and something is triggering an increase in recidivism in that 1 to 3 year period? And we don't have that data right now. But that is something we thought about too in terms of collaborative court and changing the ADP model is, is there something we can do to reduce the rate of recidivism? But I think we're going to have to look at the changes that the working groups are recommending to the ADP program, and really look at the outcomes on those to really kind of make a decision as to whether we need to shift the model or not. Melanie, did you have anything to add? Or Michelle?
I guess I would two things. One is that just recognizing that, the ADP numbers over the last handful of years have been quite low, the number of people that participate. And one of the things that we had provided to the working group, and maybe there might have been another working group here that got the information. It really is a stark contrast between the numbers from the inception of the ADP program, when there literally were no rules, to sort of seeing how the rules evolved over time and the impact on the numbers who participated over time. And now, while we can't know for certain that the reason why the numbers are so few now are wholly attributed to the rules, but it certainly appears that there's some significant correlation. So it will be interesting to see if, in fact, the board does make changes to the rules at some point, what the impact is on the participation. And then certainly it might make sense to invest more resources in a collaborative court model.
Thank you, Melanie. Yeah, just really appreciate all the work that everybody has put in on these committees. It sounds like we're heading in the right direction. Any other questions on any of that before we move forward? Okay. The final agenda item is item 4D, next steps for the ad hoc commission on the discipline system regarding the alternative discipline program project.
There's no presentation related to this, so we don't have somebody designated. The idea was for the group to determine what your next step is for these working groups. For example, if there is going to be a written report, are you ready to start drafting the written version of what's going to be recommended to the board? Because reminder of the time frame. This is due for the Melanie, correct me if I'm wrong, the November meeting, right? So it's the November board meeting. These recommendations need to be in, which means that we need to have the agenda item prepared at least a month before that. And so probably we will need to have, we're getting towards the time of having something ready that's written up for this group then to meet again as a whole, not the working groups individually, but the whole committee to meet again like we just did for the LAP rules and review what the recommendations are before preparing them to go to the board.
So Michelle, what is your recommendation then in terms of next steps so we can kind of figure out if this is, how we want to move forward? Like timeline and everything,
Timeline is, well, we don't have our next full meeting scheduled yet. But I think it would be reasonable to plan this meeting, this next full oversight committee meeting in maybe about 3 months, which would give the working groups time to put something together, to write each individual proposals about what you want to say to the board about making changes on each of your areas. And then at that meeting, we can, let's see, so that's the end of June, July, August. Yeah, so that'd be about the end of August. And then that will give us time. That meeting, you all can discuss and vote, finalize, and that will give us time to prepare the agenda item then before November.
And that'll give you enough time?
I believe that will give us enough time.
Assuming everyone agrees.
Yes,
Yes.
That works according to plan. Then yes.
Yeah, exactly.
Michelle, can you review the working groups that need to have reports for that November meeting so that we can kind of gauge, who's on the groups and whatnot?
So we have the group on the ADP process and procedures. So that was, or is, Justin Delacruz and Jim Heiting. The group on ADP eligibility is Lisa Johnson, Phil Spiegel, and Tracy LeSage. And the group on education on collaborative courts is Heather Benton and Tracy LeSage. The first two groups have more specific ADP rules to look at. The third group on the collaborative courts was more of a response to all of the stakeholder interviews that this group did at the end of last year and reported on in, I believe, March of this year. And basically all of the stakeholders who were interviewed said they didn't know what collaborative courts were. And so we need more information on that. So that might be a separate section or addendum or something that you might want to add differently, report on differently to the board in saying, here's information on collaborative courts and here's what our recommendations are, or some things to consider about collaborative courts.
So I'm thinking next steps would be for each group to get together and try to figure out who's going to write, figure out what your recommendations are, and then we can start maybe getting some drafts to you, Michelle, and Melanie, and see, and then, let's set some timelines on that. So not just we need to have it by the end of August, but, if you could get back to us with how, we need the first draft by X date and this, final draft by X date, I think that will give us some parameters to work with.
Well,
yeah, so sorry.
Yeah, I think if we can find a date for the next meeting and then we can work back from there, that would probably be most helpful.
Okay. So that's actually on it's sort of the last item is whether we want to schedule a meeting now, or would you guys like to have a poll sent out and we can schedule a meeting that way? Any preference?
Doesn't matter to me.
Yeah, I'm good either way.
Okay, well, I think for ease of things, maybe it would be good to try and get a meeting on calendar now, and then we can set those dates and, you know, we can part ways with that information.
Sounds good.
This group usually seems to be available on Fridays around lunchtime. So at the end of August, we're looking at August 30th is the last Friday in August. If you want to start there and
I will say that's the Friday before Labor Day, so a long weekend.
Oh.
What do you got in mind, Melanie? Where are you going?
Well, I don't have any plans, but others might.
People might, yeah.
Yeah.
Yeah, can we go the Friday before then?
That would be the 23rd. Mm-hmm.
Which is good works for me.
Works for me. Me too.
Can we do it in the late afternoon, like 3 o'clock to 5 o'clock or something like that? I just might be riding a horse in a competition on that day in Tennessee. So I just, you know, morning, they have morning class. They don't have afternoon classes.
Do you want to pick another date maybe then? So Fridays are late at 5 p.m. getting on the road.
Whatever. Yeah, go ahead.
What about September 6th?
Let's see, September 6th. I'm good. That works for me.
That works for me.
Good.
Okay.
9/6.
All right, so it seems like nodding heads and general agreement that everybody is available as of now on September 6th from noon to 2.
Mm-hmm.
Yes.
And then we'll send an email, staff will send emails to the working groups about timeframes that we can schedule a meeting with staff if you want to talk first, or if you would prefer to talk first and then submit some initial draft, and then we can meet together and as the working groups with staff and talk about those drafts.
Yeah, my thought is just looking at the calendar that ideally we'd have the drafts done by the last week of July, first week of August, just the first drafts, because we're going to have to go through them. They're going to have to be posted with the agenda. So we can plan to get the working groups together if that will be helpful in advance of that. I think it's likely that everyone will need to meet at least once before something is written.
That sounds good.
Yeah. And then I guess for the August meeting, are we doing that one in person, or are we doing the December one? Do we know yet?
We haven't decided.
Okay.
Yeah, I don't remember if this group had planned to have one in person before December. Sorry, I just do not remember if that was part of the conversation. Is there a preference?
Christmas party. Let's have a Christmas party.
I think we've typically done December in person.
Yeah.
Mm-hmm. Yeah, that sounds better. Christmas party.
And let's make it holiday to be inclusive.
Okay, holidays is good.
Sounds good.
All right. If there's no other questions, that concludes today's agenda. We have our meeting set for September 6th, and we are adjourned.
Awesome.
Thank you. Thank you.
Thank you. Thanks, everyone.
See you,
Have a great
everybody.
weekend, everybody.
Right. Take care.
Thank you, everybody.
Bye.
Thanks. Bye.